Breaking news: Glocks are not arms and they are dangerous and unusual. Let's go ahead and talk about it. We are back. My name is John Crump. I'm an investigative journalist, and this guy right here is Flying Rich, who we also broadcast to his channel. If you haven't checked him out, it's Flying Rich Firearms and Flying Rich on YouTube. Check out both of those channels and give him a follow because he deserves it. Now it is the day before 4th of July, so we are expecting big things today because, of course, we are. Because it's the day before a holiday and
Document Dump Friday.
Yeah, Document Dump Friday, as I call it, but it's the day before a holiday, so something always happens. A lot of people are off today, so they try to shove a bunch of stuff in there. This is interesting, the story that we have today, because California has responded to the DOJ lawsuit that is challenging Assembly Bill 1127, which was signed into law and went into effect on July 1st, and it is a Glock ban. Now, I'm going to just have Rich read it because their idea is effing ridiculous.
And I hope you people know that Crumpy just springs this crap on me, and he wants to get my reaction, so I never know what's coming.
Yeah, I think it's better that way. All right, Rich, start reading.
Even if the United States could mount a facial Second Amendment challenge under Section 12601, it has not established a Second Amendment violation. Even if the United States could plausibly rely on Section 12601 as a vehicle to mount a facial challenge to a state's duly elected, the United States cannot show that AB 1127 facially violates the Second Amendment. To succeed in such a facial challenge, which is the most difficult challenge to mount successfully, the United States must prove that the statute violates the Second Amendment in all of its applications. Knife Rights Inc. v. Bonta.
You don't have to worry about the case law.
Okay. When evaluating a Second Amendment challenge, the plaintiff must first establish that the Second Amendment plain text covers the individual's conduct.
Stop. Right there. They reference Bruin and Doe versus Bonta. Wolford said, which is a recent Supreme Court decision, the question is, are the plaintiffs members of the people, meaning the political class, those 18 and over? If the answer is yes, are the arms bearable?
Only for offensive or defensive purposes.
Yep, it definitely talk about that. You get into that. Is the arm bearable? If the question is yes, the offensive defensive purposes comes in section like step 2 of Bruin. But if the arm is bearable, then the conduct is presumptively constitutional, and it's up to the state to prove that it is not. So let's go ahead and continue reading there.
Okay. If the plaintiff meets that burden, then the burden shifts to the government defending the law to justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Bruin. The United States argues that AB 1127 violates the Second Amendment because it regulates. Where did I stop?
Just go here. Fine.
All right, hold on. I am totally lost. AB 1127 are in common use, but if the plaintiff does not satisfy the threshold Bruin analysis with simple tally of how many semi-automatic pistols that can readily be converted to machine guns under AB 1127 are sold or possessed, a number that merely reflects the fact that firearms manufacturers have chosen to not include design modifications that can prevent such conversion as standard equipment. And then it's saying Duncan whatever. And a Ninth Circuit rejected the simplistic approach, reasoning that the prevalence of a design feature is not dispositive of whether it is constitutionally protected, because there is no constitutional right to factory settings where it is otherwise. The constitutionality of state law ban on machine guns would suddenly change from a constitutional to unconstitutional if more civilians purchase machine guns. But Duncan explains that it is not how the Second Amendment works. Similarly, if modifications that prevent semi-automatic pistols from being readily converted to machine guns become standard design features, would AB 1127 suddenly switch from purportedly unconstitutional to constitutional in the United States' eyes? This is not a far-fetched possibility. Indeed, a manufacturer impacted by AB 1127 indicated in an unrelated court filing in March 2026 that it had made extensive efforts to redesign Glock pistols to prevent the use of known MCDs, machine gun conversion devices, or as we know them, switches, provides a pathway for such manufacturer to make a pistol model available for retail sale, and see whatever code, requiring that certain semi-automatic pistol models have design modifications to prevent their ready conversion into machine guns using a device that the US ATF acknowledges is becoming increasingly accessible, is not a ban, and any ancillary right to acquire firearms does not encompass a desire to purchase ones that can be easily modifiable into machine guns. And citing some case law, and to scroll down, up, and I don't know where we are.
We start at the top. I got it so it's set to the top.
Does not elevate convenience and preference over all considerations. Properly analyzed, California's commercial requirement that semi-automatic pistol models available for retail sale in the state not fall within the definition of a machine gun convertible pistol does not meaningfully impair an individual's ability to access firearms, just as the Second Amendment's text covers modern instruments that facilitate
sorry. I didn't mean to do that.
Facilitate armed self-defense. In Duncan, quoting Bruin, the text does not preclude the states from addressing regulatory challenges posed by firearms today by requiring modern weapons to have modern safety features that reduce the risk of unintended harm. And they're citing Bruin. These reasons, the United States has not met its burden at Bruin's first step. Moreover,
but stop there. But basically, they're saying that Glocks are not covered by the plain text of the Second Amendment. So, wow, they're right there. That's basically saying Glocks are not arms. All right, keep on going.
Moreover, even after Bruin, the Ninth Circuit has reaffirmed prior precedent that machine guns are dangerous and unusual weapons that fall outside the scope of the Second Amendment because machine guns can fire more than 1,000 rounds per minute, allowing a shooter to kill dozens of people within a matter of seconds.
All right, so right there, they're trying to say that Glocks are dangerous and unusual, even though they're the most commonly owned handgun in the United States.
Let's see. Circuit has reaffirmed prior precedent that machine guns are dangerous, unusual weapons that fall out. Okay, I read that.
So basically, what they're saying is that that Glocks are not arms covered under the Second Amendment, and they are dangerous and unusual.
Okay, and then they're saying Supreme Court observed it would be startling to read the Second Amendment as prohibiting a ban on machine guns. In other words, it's okay to ban machine guns, which I disagree with.
Aaliyah said that.
In any event, a step 2 Bruin analysis shows AB 1127 is consistent with the historical tradition of firearm regulation identified in the Ninth Circuit's court historical analysis in Duncan, as Duncan recognized mass shootings are clearly a societal concern that arose only in the 20th century.
What does that sound like to you?
Well, they're changing the scope of when the 14th Amendment was ratified.
No, they're saying the 20th century, so they're using interest balancing,
yes,
intermediate scrutiny, which is not allowed. Keep on going.
and that firearms that existed around the founding and after Civil War fired much slower than uh, I can't quite read the rate of modern semi-automatic firearm, let alone compared to the rate of a machine gun. Semi-automatic pistol can be readily converted into a machine gun with a 3D printed pistol converter, thus a distinctly modern. Scroll down.
I got it.
Modern problem. Okay, so they're saying Wolford is credited with that. Duncan went on to explain that beginning before the founding and continuing through the nation's history, legislatures have enacted laws to protect innocent persons from especially dangerous uses of weapons. Once those perils become clear, these historical laws fell into three categories, including gunpowder storage.
Stop right there. Stop it. Why was the gunpowder storage laws?
Because everybody heated and cooked with an open flame in something like a Franklin stove, or prior to that, just a fireplace, and most women died getting burned to death while cooking because their clothes caught fire. So, fire in gunpowder in wood frame homes was not a good thing, and the whole community could burn down.
All right, read the next one.
Okay, trap gun laws.
All right, well, trap guns. It's not like shooting trap. What they're talking about is booby traps.
Yeah, which is illegal, period.
Yeah, you open a door, a gun fires.
Or anything like bear trap. You know, you can't do those things against
that's
humans.
That's booby trap laws. That's setting up booby traps like we're out of Indiana Jones.
And again, this is the tried and true methodology that they've always used, that the left always comes up with. It's like, yes, play that tune again. And restrictions on particular weapons after their use by criminals exposed an especially dangerous use of the weapon. These sets of historical laws.
Right there. What they're talking about is Bowie knives, and what they're talking about is it didn't regulate that you couldn't carry a Bowie knife or anything. What those laws said is you couldn't carry a Bowie knife and threaten someone with it. So basically, brandishing laws.
These sets of historical laws demonstrated a clear pattern that when a criminal took advantage of technological advances in weapons, legislatures acted to restrict an especially dangerous use of those weapons. This historical inquiry is consistent with the purpose behind AB 1127, which responds to the US ATF's acknowledged skyrocketing criminal use of machine gun conversion devices on semi-automatic pistol models at this early stage in the proceedings. The historical principles identified by the Ninth Circuit in Duncan, at minimum, demonstrate that any historical inquiry cannot be resolved in the context of a TRO, and that more time is needed to compile the historical record for Bruin's second step, to the extent that reaching this step is necessary in the first place. The United States accordingly fails to establish that AB 1127 constitutes a facial violation of the Second Amendment.
So what they're saying there is that even if you do believe that Glocks are covered under the Second Amendment, which we don't believe because they're not bearable arms, and because they are dangerous and unusual, which is absolutely ridiculous. Even if you do want us to do the step 2 of Bruin, which is a historical analysis, you shouldn't issue a TRO because it's going to take time. This is absolutely ridiculous. Really, really ridiculous.
It's crazy to me. Well, first off, there's laws against converting a semi-automatic firearm into a machine gun, and we all understand that, and we all want to be way within, like, don't even want to approach the gray areas. We want to be, as law-abiding citizens. Criminals will criminal, and because
I don't know. I mean, I kind of want to make a machine gun.
Well, I do too, but I want to do it legally. But criminals will.
Machine gun.
But you're not going to be mowing down your neighbors with it.
No.
And So here's the big problem: is you're penalizing all of the good people that are law-abiding citizens for
A
some number,
vast majority.
yeah, for some small fraction that are criminals. My second issue here is that I almost rather have thugs having machine pistols because then they won't be able to aim.
Yeah.
That's the spray and pray.
Yeah. Yeah. They're punishing, well, they're not even okay, I say they're punishing the vast majority of people for action, the criminals, but I don't think that's it. I think they're using criminals as an excuse to ban the most popular handgun in America.
I completely agree. I mean, they're going after Glocks and they're going after AR-15s, and those are the most popular firearms. Period.
Yeah, we settled this in Heller. You cannot ban a handgun because they are in common use. Heller was very, very explicit about this. So I don't even know how the Ninth is really anti-gun. I don't even know how they're going to uphold this.
Well, look at the Supreme Court. We always have these 6-3 decisions, and the left members of the Supreme Court, regardless of laws or facts or the Constitution, they go with what their party wants, or their, should I say, master's desire. And that's what we're stuck with. Unfortunately, they're not going by, where's my pocket Constitution, the rule of law.
Yeah, this is absolutely ridiculous. I've never, ever, ever seen someone go this far to claim handguns are dangerous and unusual and can be banned and are not arms.
And I guess the other crazy thing is it is more difficult to make a firearm semi-automatic than it is to make it automatic.
That is true.
And so anything that any kind of firearm, like if they succeeded on this argument, then all firearms are easily convertible into machine guns.
I can give Mr. Willie out there, if you haven't seen him, he's a mad scientist, anything, and he'll convert it into a machine gun.
He took an FN57, which there's not a lot of area in there to make it a machine gun for specialty parts, and he took a Desert Eagle and made it a machine gun. So that is some mad skills.
Yeah, so you can make anything into a machine gun. The reason why they are targeting Glocks and also any pistol with a cruciform trigger is because Glocks are the most popular handgun in the United States, and there's a lot of other handguns, the Dagger, the Shadow systems. There's tons of other handguns based on that design.
And again, this is just lefties on parade doing what lefties do, and that's gun grabbing.
And if they're successful at this and this gets upheld, they're going to say, oh, this other gun can be converted, so let's ban big P320s with their automatic fire feature.
Or what the Tech 9, which firearms that fired from an open bolt, they were quote unquote readily convertible. So they made sure you couldn't, they basically banned that.
They didn't really ban open bolt guns per se. They just became a very, very gray area. You can basically, they said, oh, if it was originally designed as a machine gun and it was an open bolt, you made a semi-automatic version of that, you can't have it be an open bolt.
So the later versions fired from a closed bolt.
Yeah. So that's kind of what they said. It's a dodgy area, open bolt versus closed bolt.
And Jovac Q, a wealth of knowledge, manufacturers stopped making them voluntarily.
Yeah.
And that's like, the ATF tapped him on the shoulder, said, yeah, not so much.
Yeah, they did that to get out of the readily convertible maybe type thing. But they're open bolts. are gray area, and I understand why manufacturers don't make open bolt guns or semi-automatics, but
Now,
it
readily convertible, was that for machine guns or was that for the Italian starting pistols that were coming over?
originally for the Italian starting pistols. If we
Okay.
do, you know what? I'm gonna let you explain that.
So what was happening? Was it the GCA that had
Yeah,
readily convertible?
1968. Yep,
So the GCA had readily
gun control act,
convertible in
1960.
it. What was happening is you could buy Italian starting pistols, and what it was a revolver, and it had just a piece of lead jammed in the barrel to deactivate it from being a functional firearm. So all you had to do is take a dowel and hammer the lead ball out, and you had a functioning firearm. So readily convertible wasn't to make it from what it wasn't to what it is now. It's to restore functionality as a firearm.
Correct. Uh, yep. M. Gabriel says, "Isn't that 122 LR open bolt still okay, though it is not manufactured anymore?" Yeah, yeah, it's okay. That's what I was trying to um explain that it's a gray area, right?
Yeah.
So open bolt does not specifically fall under readily convertible, but you're getting into a very, very gray area where they used that as readily convertible because they said it was designed to be a machine gun and then convert it into a semi-automatic. So it's very, very hard to get a open bolt gun that fires more than one round at a time through the process, and I don't see the ATF approving any open bolt semi-automatic designs, even though technically it could.
Oh, I clicked on the wrong one.
What are you trying to do?
I just want to click on that one.
Oh,
They know this ban is illegal. They're just trying to. Yes, of course. The process is the punishment.
yeah. Yeah, basically, they always say that open bolts are readily convertible because 'cause they're easier to convert. Jovaku is right. But if
Yep.
you were able to design something to prevent it from being converted easily, then it wouldn't be banned. So,
So here's a good question from M. Gabriel. Does the ATF have to approve designs?
well, they issue opinion letters. You technically don't have to send them something, but most manufacturers do.
Yeah, there's no law or regulation, but if you want to make sure you don't have future problems, the idea is you send it to the ATF and they offer an opinion.
Yeah. Yeah. Um, we know people that have done that. But yeah, this is an absolutely bonkers argument. And
That so I mean there was as far as I know, is there other Glocks? I mean the Glock 18 was full auto. Are there other Glocks that were full auto or from the
all
factory?
in the Glock 18 family, Glock 18, Glock 18C.
So, Glock has made full auto pistols, but all of the other pistols are manufactured from the factory as semi-automatic.
Yep. And they were originally designed as semi-automatic. They didn't go from automatic to semi-automatic. They went from semi-automatic to automatic when they came out with the Glock 18. So the Glock 17 came out before the 18. Then the 19 came after the 18, of course.
So yeah, this is more tyrants tyranting.
How far do you expect this argument to stand? I think they're going to lose. California's going to lose in the district court. Depending on the draw they get at the panel at the ninth, they might win. They might lose at the ninth uh, panel. Then when it goes en banc, who knows?
And so what John's talking about is the different levels. So the federal government is suing California in the California courts, and then it has to work its way through the courts. So it depends on the judges and their, personal opinion. And I hate to say it, if I was a judge and I disagreed with something, but it was the law, I'd be like, all right, while I disagree with it and I don't think this is right, this is what the law says. That I would be that person.
Yeah, it's something a conversation that we had the other day.
Whereas, if you have a political allegiance to a certain philosophy and that overrides any legal history or constitutional regulation, that's wrong. That's wrong if you're going on your gut as opposed to law of the land.
Yeah. Remember what we had a conversation about another case that was not gun related. And I was like, yeah, it kind of sucks, but it probably was the right decision.
And Van Dyke is our superhero in California.
Yeah, I know one of his clerks.
So
I met Van Dyke.
So Van Dyke is the guy. He actually posted videos from his judge's chamber showing firearm functionality.
At SHOT Show, I tried to get you to come down to meet Van Dyke, but you said you were busy.
Crump, I have to? I'm just gonna crazy glue myself to you next year at SHOT Show.
Did you not say when I said, "Hey, can you come?" And I got something for you to meet, and you said, "Oh, I'm busy, man. I'm doing something else."
All right, Crump. I'm just gonna glue myself to you in 2027.
Did that not happen? Then you're like later on, who was it? It was like Judge Van Dyke. You're like, God, what are you telling me? I was like, I got someone for you to meet. Then I tricked Rich. I said, I got somebody for you to meet, and it was the
ATF agent assigned to watch our channel.
Yes. Benitez is retiring or has retired.
Oof. Oh man. That's and I don't. Well, actually, I don't want to talk ill of Mitch McConnell, but Ruth Bader Ginsburg. And again, not like I want to give the Democrats any ideas on how to do things, but she should have stepped down during the Obama administration when Obama could have replaced her with another liberal, and she didn't because I guess the power is just all intoxicating.
Yeah, the thing that worries me in this case is the judge in this case is Ann Huang, who is a Biden appointee.
Yeah, I just wish people upheld the letter of the law, followed the Constitution. The Second Amendment doesn't even say bearable arms. So when somebody says bearable arms, I kind of cringe. And it also doesn't say semi-automatic only or bolt action only. So I have some issues with all of that. As far as I'm concerned, if it's an arm, it's an arm, and it's your right to keep and bear it. Just like Joe Biden said about cannons. Cannons are completely unregulated. There is no regulation for you can buy a cannon. You can build a cannon. Nobody cares. ATF doesn't care.
In fact, Mr. Snow, because Biden said that, bought a cannon on eBay.
Delivered to your front door, no FFL, nothing.
Yeah.
And he mounted a Gideon optic on it.
So Ann Huang is that's the only thing that I'll worry about is they drew Ann Huang, and he is a Democrat. But let's see.
I love this. My high school teacher literally brought a cannon to our school and fired it as a demonstration. I hope he had something in there, a projectile, not just powder, and showed you how many pieces of plywood it'll go through.
But she is on record saying that she would apply binding Supreme Court and Ninth Circuit precedent to I can't say that.
Precedent?
Yeah, precedent to the Second Amendment. And she quoted said, "When the Second Amendment plain text covers individual conduct, the Constitution preemptively protects that conduct." And basically talking about the Bruin, so who knows?
It's amazing to me because John has talked about it. I feel the same thing, that the Constitution, the Bill of Rights, is a charter of negative liberties against the federal government. It says what you can't do to the people.
Yeah.
The first 10.
Oh, you use my phrasing.
Yes, the first 10 amendments to the Constitution are the people, and so when they always argue that the Second Amendment is for a militia, no, every other right in the Bill of Rights is for the people, period. It's not for an organization, a group, or a class of people. It's for the people, period.
Yeah. And I would like to say, like to quote the great David Brown, who is one of my attorneys. And he says, if it was a collective right, that would be like the Navy granting itself the right to own boats. But yeah, that's all I have today.
Alrighty, Crumpy. Well, happy Independence Day tomorrow, and to the rest of our wonderful audience. For those of you in the United States, and for those of you elsewhere, God bless you. God bless America.
But yeah, there is another case that I'm thinking about doing something on, and this is about the California 3D printing bill has been amended again, but we'll let that go for now. They made it, they removed the part about making it illegal to circumvent gun blocking technology.
So you can print no, in California
you can modify it because whatever.
They're prohibiting you from, or they want your printer to figure out whether it is or isn't a gun and not allow you to print it. And if you circumvent that, you're doing something illegal.
Yep. All right. With that, we're out of here. Thank you so much. And I might do a video later on that. It just depends. Yeah. All right, guys, you enjoy your 4th of July, Independence Day. I'm going to go watch Independence Day with my kids today.
Nice.
This is our Independence Day. No, I don't want to get copyright struck, so I'm not going to do it. All right, I'll see you later.